Good morning, good afternoon, and good evening to everyone joining us for this, the second day of the second Symposium on Reparations under International Law for Transatlantic Chattel Slavery in the Americas and the Caribbean. This is the final day of the second of two symposia, and we are delighted that you could join us again. For those who are just joining us, and were not able to tune in yesterday or to view the video yesterday, we will begin with a short summary of what happened yesterday during the first day of the symposium. First, allow me to introduce myself. My name is Natalie Reed, and I have the pleasure and privilege of being one of the organizers of the symposium. Yesterday, during the first day of the symposium, Judge Robinson reminded us of the conclusions of the last symposium, which established that transatlantic chattel slavery was unlawful at the time it was committed, and that as a result, former slaveholding countries have an obligation to make full reparation under international law to the descendants of Africans they enslaved, but that neither that determination nor the calculation of the amounts due can be left up to the perpetrators. Beyond monetary payment, international law also requires that satisfaction be given, including if compensation would not be sufficient to fully remedy the wrongs. That satisfaction could, of course, include a formal apology and depends upon the nature of the wrongs in question. It may include, of course, consideration of whether, for example, the psychological harms that were suffered by those who were enslaved may be appropriately addressed by monetary compensation or by some other form of remedial step. Judge Robinson also discussed recent developments in between the first symposium and this symposium, such as acknowledgements from governmental and major institutions of European countries, and noted that these had been a positive step. For example, the apology offered by the Prime Minister of the Netherlands, but that the steps that had been discussed publicly in recent times may well be insufficient to fully address the harms committed during transatlantic chattel slavery and the consequences, the enduring legacy of transatlantic chattel slavery that we continue to see and feel today. We then heard a powerful keynote address from Sir Hilary Beckles, Vice Chancellor of the University of the West Indies, who explained that the impacts and the consequences, again, of transatlantic chattel slavery, not solely from a legal perspective, but also from a historical one. And from that historical perspective, discussed whether and how transatlantic chattel slavery at different times could be considered to have been a form of genocide against the populations involved. Sir Hilary elaborated on the situation that enslaved peoples were left with after slavery formally ended. And in response to questions and observations from Judge Robinson, offered insightful comments on whether and how those who are seeking now to grapple with the consequences of transatlantic chattel slavery, including the legal qualification as genocide or other breaches of international law, could infer intent behind slave owners' conduct and policies throughout the relevant period in the Caribbean and throughout the Americas. We then heard from the economists of the Brattle Group, who presented in a briefer form than the report, which is also available from the webpage for the symposium, the estimate, the calculations, the quantification they had prepared of reparations due first for the period during transatlantic chattel slavery, and second for the period after transatlantic chattel slavery. The colleagues from the Brattle Group, Dr. Vargas and Dr. Bazelon, in addition to presenting those figures, really grappled with the idea of the scale of those figures and provided some context and perspective on how the sheer mind-boggling, in some ways, sums involved really reflect both the number of those who were the initial victims of transatlantic chattel slavery, the period over which the breaches of international law were committed, and of course, the important consequence of the passage of time since those initial breaches were committed. Among the heads of damage that the Brattle team considered, of course, as guided by Judge Robinson's legal framework, were damages for loss of life, uncompensated labor, loss of liberty, gender-based violence, and for the period after transatlantic chattel slavery, using wealth disparity as a method of capturing a number of different harms that we continue to see today. We then had our first panel of discussants with Dr. Mamadou Ebiye, Professor Don Marshall, and Professor Adrian Wing, who discussed the analysis that had been presented by the Brattle Group, but also took a broader perspective and highlighted the differences between, for example, the economic approach and the legal approach to damages, reminding us that we could also consider whether and how reparations are owed to the African states, and emphasizing that reparative justice must be ethically driven and not solely economically driven, as well as pushing us to take significant considerations, such as really building on gender-based violence assessments and intersectionality in those considerations, whether and how to take those further into account in the calculation. Today, we are delighted to welcome additional esteemed discussants to continue this discussion. And we will hear from Judge Abdulkawi Ahmed Yusuf, member and former president of the International Court of Justice, Dr. Mojtaba Kasazi, former executive head of the United Nations Compensation Commission. We will then hear some additional comments from Professor Vereen Shepherd, the director of the Center for Reparation Research at the University of the West Indies, who of course has been a key participant in both symposia, is a member of the advisory committee convened by Judge Robinson for this symposium. And then we will hear some concluding remarks from Judge Robinson himself to wrap up the day and this symposium. To introduce our discussants, again, their biographical summaries are available from the webpage for the symposium. But I will very briefly introduce them, and then we will move directly to hearing from each of them. So Judge Yusuf, as I mentioned, is very well known to many of us in the international community as former president and remaining a member of the International Court of Justice, where he has served on the court since 2009. Judge Yusuf, of course, has spent many decades of service to Somalia and to the international community. From 1975 to 1980, he served as Somalia's delegate to the Third UN Conference on the Law of the Sea. He, of course, has taught and written extensively, including from the 1970s onwards. From 1987 to 1992, Judge Yusuf was chief of the Legal Policies Service of the United Nations Conference on Trade and Development, UNCTAD, before becoming its representative and head of its New York office from 1992 to 1994. From 1994 to 2001, he served as legal advisor up to 1998, and then assistant director for African Affairs for the United Nations Industrial Development Organization in Vienna. From March 2001 to January 2009, Judge Yusuf was legal advisor and director of the Office of International Standards and Legal Affairs for the United Nations Educational, Scientific, and Cultural Organization, UNESCO. In 2001, Judge Yusuf joined the Advisory Council of the Hague Institute, in 2011, joined the Advisory Council of the Hague Institute for Global Justice. Judge Yusuf, of course, as part of his distinguished academic career, has been founder and general editor of the African Yearbook of International Law, and is a member of the Institut de Droit International. He is one of the founders of the African Foundation for International Law and chairman of its executive committee. Judge Yusuf, we are delighted and honored that you will join us this morning and this afternoon. Dr. Mojtaba Kasazi, as I mentioned, is former executive head of the United Nations Compensation Commission, and of course was instrumental in setting up the UNCC and in resolving 2.7 million claims from over 100 countries. He's also recently served as the executive commissioner of 2 international mass claims programs for payment of compensation to workers. Dr. Kasazi has had as well a long and distinguished career in national and international service, having been a former judge in the courts of Tehran and worked extensively on the arbitration and settlement of claims before the Iran-US Claims Tribunal. He has also served as a vice president of the Institut de Droit International and as a visiting scholar at the Graduate Institute in Geneva. Dr. Kasazi currently sits as an independent arbitrator in different disputes and serves as a board member of the Tehran Regional Arbitration Center. Dr. Kasazi, we are as well delighted and honored that you're able to join us today. So Judge Youssef, if I may turn to you first, we welcome your comments and observations on the points made in the Brattle report, and more broadly on the question of reparations for transatlantic chattel slavery under international law. I believe that you are currently on mute, sir. So if the administrator could take Judge Youssef off mute.
No, I think
yes,
it's fine.
Excellent. We can now hear you.
The
floor is yours, Judge Youssef.
Yeah. Thank you very much. And I will not take much time because I don't really have a lot to say about the report. I think it is a groundbreaking report. And I believe that that groundbreaking possibility was also offered and facilitated by the first symposium and the legal guidance and legal framework paper that was prepared by Judge Robinson. Because I think Judge Robinson's paper gives us the legal basis on which discussions and debates on reparations can actually be engaged and can be pursued because it clarifies the legal issues arising from the chattel slavery of Africans several centuries ago. And of course, it is continued effects and impact on the descendants of the slaves and on the people who live in many parts of the world who were unwillingly and forcefully uprooted, transported, and used as uncompensated labor in plantations to produce for the benefit of economies in the Northern Hemisphere. And I think that in your summary, you just mentioned that one, of course, of the speakers mentioned yesterday that slavery could also be considered as a genocide. I think we should stay away from that. I say we should stay away from that because slavery was undertaken because the slaves or the enslaved persons were needed actually as uncompensated labor. So there was no intent to get rid of them. And those who died were actually a loss to the slave owners, because these people were treated as goods, and as goods which could actually provide services. Not just, they were not commodities only because they were dehumanized, but they were commodities that could offer services which can be monetized. And therefore, they were useful for those who engaged in slavery. And the intention of the slave owners could not be and was actually far away from an intention to get rid of them, or to destroy them as human beings. They were very useful for them, and therefore they wanted to keep them alive. And that was also part of the trade because they were being used as tradable commodities. And you don't want your tradable commodities to be destroyed or lost. Now, some of the major issues that have been raised by the report of the Prater Group, actually my attention was drawn to the fact that I think it is in the last page of the report. No, it is on page 70 of the report. There was a placeholder on proportional and allocation needs to be revised. And there was also a reference to the countries which by whom countries which owe the 100 trillion in reparations. So the reference read is the more than 100 trillion in reparation is owed are not owed by a single country. And I think we have to revisit this kind of remarks, and I will place them actually in the context of the entire discussion, because I think it is very important to address not only by whom the reparations are owed, but to whom they are owed. And maybe it is much more difficult. It's not that easy in any case to establish to whom they are owed. And that is not also very clear either in the original papers or in the Prater Group papers. And if we take, for example, loss of life, we will have to see where those lives were lost. Were they lost immediately after the capture of the enslaved persons? Were they lost in the dungeons in which the slaves were kept before embarkation and shipment? Or were they lost in the Middle Passage? Or were they lost in the plantations or in the slave labor camps where many of these people were used as slaves? I think it is very important that these issues be addressed, because then, of course, those to whom the reparations are owed will be different. Whether the reparations are owed to African communities who are still in Africa, or whether the reparations are owed to communities who are in the diaspora, African diaspora, who are the descendants of slaves. And the other important question with respect to whom it is owed, the reparations are owed, is actually, the reparation is owed to a country or to a state, or are the reparation is owed to a community or a collectivity, or are the reparation is owed to individuals? And that's very important also, because I think that this needs to be discussed and to be clarified, because it will be different in each of these instances. What kind of reparations will have to be considered for different categories of for different entities to which the reparation is may be owed. Then I come to the two categories, or in the case of the paper, I think that was originally prepared by Judge Robinson. Actually, there were three categories of reparations, I think. Reparation is for consequences of the wrongful conduct of transatlantic chattel slavery in the period following its formal termination. That was the first category. And then there were two categories of reparations for the continuing breach of the obligations owed in respect of transatlantic chattel slavery. One for the period in which these persons were still kept as slaves, or were actually still being treated as slaves, although the legislation, there was legislation which actually terminated slavery. And therefore they were not being traded, but they were still being treated as slaves. And one continuation which concerns, as I understand it, discrimination against the former enslaved persons and their descendants. And in the Pratal group, I think there are two major categories. Reparation is for the enslaved and the persons who were subjected to slavery and to uncompensated labor, and who were deprived of their liberty, etc., and who were subjected also to sexual violence and assaults. And reparation is for continuing breach of the obligation through the treatment, discriminatory treatment, meted out to the descendants. And for the first one, the Pratal group made a quantification of about, I think, 78.7 trillion, while for the second, they made a quantum of 22.6 trillion. And of course, these are huge amounts of money. But before actually dealing with this amounts of money, one has to deal with the purpose and objective of the reparation, for example, in the first case. In the case of the reparation is for loss of life, for uncompensated labor, etc. What would be the purpose? Would the purpose be to compensate those who are alive today and who are the descendants of the slaves, and to pay them for the treatment that was meted out to their ancestors? Or is the purpose to compensate the communities from which these persons were taken and which were deprived of these people as a community, and which suffered, of course, because of the fact that part of their population was taken away by force and shipped to far-off lands. So that is one issue. The second issue is to whom would this compensation be paid? As I said before, I think it's not easy to determine that, and whether it is states, collectivities, and for what purpose would it be used in any case. And I think, therefore, that the focus should not be on this first type of reparation in the form of compensation. I think the focus, in my view, should be on the second type of reparation, which would not be only in the form of compensation, but which would also be in the form of satisfaction. Although, of course, satisfaction could also be applied to the first form of reparation. Why do I say that we should focus on the second? Because I think that there are millions, tens of millions, hundreds of millions of people who are still suffering, hundreds of millions, in fact, who are still suffering from the effects of slavery. And I think it's not only Article 14.2 of the ILC articles to which Judge Robinson referred in his paper, but I think it is very important to keep in mind Article 30 of the ILC articles on state responsibility, which actually says that the state responsible for the internationally wrongful act is under an obligation to cease that act if it is continuing, to cease that act if it is continuing. And since, of course, and I agree with Judge Robinson, that there is a continuing breach of an obligation, and that the acts of slavery are continuing in the form of discriminatory treatment of the descendants of the slaves. It would be very important today to ensure the cessation of those acts. And the cessation of those acts will not only come through compensation. It will not, in my view. It will come, I think, mainly through satisfaction. And I am talking here about satisfaction in the form of, for example, a correct account of what happened, an accurate account of the violations. That's what I mean. An accurate account of the violations and the inclusion of that accurate account of the violations in educational material at all levels throughout the world and throughout those countries where slavery was practiced. And I think this is extremely important. And it is also important to have, as another form of satisfaction, a public disclosure of the truth about slavery. Because I don't think that many of the societies are aware and know the truth about slavery. Of course, for example, now in the Netherlands, there was a report about slavery. And as a result of that report, the Prime Minister offered apologies. But are the conclusions and the facts that have been established through that report, are they going to be part of the curriculum that is taught in schools in the Netherlands? Is there going to be an accurate account of what the Dutch slave owners did and how the Dutch East Indies Company behaved and conducted itself in the acquisition and in the trade, in the slave trade? So those are, to me, an extremely important considerations to be kept in mind. And I think those considerations will have to relate to the post-enslavement period and the continuing breach of the obligation, the discriminatory treatment of the descendants of the slaves, and the need for cessation, because this should finally somehow come to an end. And unless it comes to an end, no amount of compensation will be able to repair and to remedy the damage done. And I think I will stop there. Thank you.
Thank you very much, Judge Youssef, for those observations, the questions raised, the points made. While you were speaking, you had referred to a table in the Brattle report, and we briefly showed that table. If I could ask Mr. Riss to show the table again, just so that our colleagues watching on Zoom and the YouTube feed can see it. The report is, of course, available from the Symposium website. And the particular table that Judge Youssef was referring to is table 29 in the report, which is now on your screen. I would encourage anyone watching to review the full report, including this table, and of course the tables, the figures, and the analysis set out in the in full in the report, to understand how the Brattle team developed the figures And of course, we look forward to hearing from Judge Robinson in his closing remarks, thinking about how some of the questions and considerations raised by the discussants, including those yesterday and Judge Youssef now, will be taken into account going forward. We now turn to Dr. Kasazi. Again, we are indeed honored to have you with us today, Dr. Kasazi, with your extensive experience in dealing with mass claims under international law. The floor is yours, sir, to provide your comments and observations.
Thank you very much, Ms. Reid, for the introduction, but also for the excellent summary that you made of the proceedings of yesterday and the important point that you highlighted. Good afternoon and good day to everyone. I am very pleased and honored to participate at this symposium and be a member of this panel with Judge Youssef. And I just enjoyed very much listening to him and to his thought-provoking presentations and the issues that he raised. I would have liked to make some comments on that, but I don't think I have time. I leave them for Judge Robinson. The purpose of the Brattle Group report, which we are reviewing here, is to quantify and put monetary value on all the harms and damages caused by transatlantic chattel slavery. This is, of course, a very difficult and challenging task that the authors have referred to it with expressions such as seemingly insurmountable and hopeless. Nevertheless, they have managed to harness this complicated task very well, and with the help of their own knowledge and research and benefiting from the available academic literature and the body of work already done by many researchers and scholars on this issue in the last few decades, it seems that the authors have become confident enough to make a number of good assumptions on key issues that were necessary in order to arrive at a reasonable and convincing results. And I commend them for that. The task, of course, is not finished, and there are areas to refine and reinforce and to add more diverse backgrounds and statistics to the report. And to go back again to what Judge Youssef mentioned, I think some of those comments have also added some needs for extra review of the report and fine-tuning them. With the time available, I would like to mainly address 3-4 important issues. First, I like to look at the main methodology and model with the material assumptions, which have far-reaching effect on the quantum of compensation. This is, in fact, the part that deals with the loss of life and uncompensated labor. Also, for the same reason, I like to review the interest rate and its impact on the quantification of compensation. And finally, to look at what is not in the report and perhaps should be there. The authors themselves have been very open and transparent on the shortcomings and the limitations of the report. The most obvious and important unquantified element of loss is the one that yesterday Judge Patrick Robinson highlighted, i.e. psychological harm. I like to discuss this matter in light of the practice of the United Nations Compensation Commission, where mental pain and anguish was calculated and compensated for thousands of victims of military operations. And I don't see any reason that we shouldn't be able to do it here. Before starting on these items, I like to emphasize the importance of the statement that the authors of the report have rightly made in page 11 of the report, where the report says, quote, "There is no amount of money that would repair the harm of the enslaving millions of Africans and their descendants." The authors have also included a thoughtful quote from Professor Shepard on that matter. I like to associate myself fully with both the statements of the authors and Professor Shepard. Now, overview of economic framework. If we can go to page 13 of the report, that would facilitate the presentation.
I believe it is PDF page 13, printed page 8 of the report.
Thank you very much. A brief comment here. The quote from the Human Rights Commission is fine here. However, it seems to me it will be more appropriate to add or even to start with reference to the work of the International Law Commission on the draft articles on state responsibility for internationally wrongful act. Yesterday, Judge Robinson, in his systematic approach on legal issues, summarized the relevant articles. Those articles could be added here. In addition, I would also add Article 38 that confirms that interest is part of compensation and should be calculated to ensure full reparation, and that the rate and mode of calculation should be set to achieve that purpose. I would also add now, in light of what Judge Youssef said, the article mentioned, the article that he referred to on the same set of draft articles that refers to the obligation to cease the wrongful act and the cessation. That would be important to be mentioned here as well. If we can go to the next page, please. The table 1. This is an important table here that shows the interest rates over centuries. I agree with the approach taken in the report that inflation, it has calculated the inflation separately from the real interest. The obvious reason and immediate reason for this approach is that inflation, as was explained yesterday, is in fact the main component of the interest rate, of the nominal interest rate. When we take inflation out of what we recognize generally as interest, what remains comprises real interest rate and risks. Sometimes that risk referred to as political risk. Now, political risk or generally risk, I don't think are accounted for here. And yesterday, Dr. Basilon confirmed that it is because it has been assumed that the countries involved are able to pay and there's no risk. I think it's possible to view the situation differently because the risk is more general than that, it seems to me. And for me, any debt that has not been paid for a long time, here it is hundreds of years, is a risky debt. So I leave this as a question for the authors of the report and whether it would have any impact on the calculation or not. The other point here on this for the table is that the shortcut that the authors have found for avoiding a long and complicated calculation of interest is very helpful. At the same time, as explained later in the report, the bulk of the calculated compensation is on interest because of the length of time, which is quite unusual and is exceptional because of the circumstances here, because of the long period of time that has passed. So it is important that the calculation be reliable for such a heavy weight that we are going to put on that. And finally, I see that the rates it's on the question of the interest rate use, I see that the rates in the table are all much higher than 2.5% use in the report. Also, in the two paragraphs below the tables on the same page, I see that a slight contradiction. The first paragraph says that the 3% nominal interest rate used in the literature is lower than the average rate and would be a conservative and reasonable rate. So 3% is okay. However, in the second paragraph, the report calculates a nominal rate of 2.5%. We will come back to this issue of interest at the later part of the report when we look at hopefully table 30. Now, if we can go to loss of life and uncompensated labor and go to page 24 on the version that I have. Loss of life and uncompensated labor accounts for the main portion of the total calculated compensation. By quantifying these two important elements of loss together and applying a common methodology on both, the authors have saved lots of time and have made an amazing shortcut, which has resolved lots of issues. Not to mention that apparently this was also necessary, this imaginative way to avoid the problem of lack or shortage of data. The main assumptions that have been used here are, first of all, they have to make an important choice between the value of a statistical life methodology and loss of productive life methodology. I agree with their choice, which is the second one, which simply means, as you know, that taking the earning of the deceased and extrapolates that into the future to the expected earning period on the basis of the life expectancy, and then calculate the compensation on that basis. I think this is the right choice that they have made, also because of I refer to International Labor Organization's Employment Injury Benefit Convention number 121, which is very well known in ILO and in the labor organizations, which follows the same methodology and do that. And in fact, we and I personally use this for the calculation of compensation for the victims of the Rana Plaza disaster in Dhaka, and also for the victims and for the injured and deceased workers from the Tazreen fashion company fire, which was a big loss. And finally, in UN Compensation Commission, where there was a need to calculate loss of life for a large number of people, this was the method that was used also based on the precedent. Now, if we continue, the main assumptions that have been necessary for these two elements of loss, the first one is the number, the total number. How many enslaved persons were involved. As you see in the reports, there has been a relatively good portion allocated to these, and it tells me that the authors were fully aware of the importance of this figure, and they have documented it very well. Now, if we please can look at figure 4. In my version, it is on page 26. Yes, thank you. This shows a good portion of the methodology that has been applied. The life expectancy for enslaved, for non-enslaved, and then loss of life. This is what I call the genius, because the way this has been calculated, the authors didn't have to calculate separately for the deceased. And in fact, they have calculated for all the 20 million enslaved that they have calculated, and they have assumed that everyone was alive until the end period of the life expectancy of a non-enslaved person. And with that, they have come up with all the figures that have. This means, of course, for compensation for the, I'm sorry to use these words, for the life and death have been calculated the same. They have been treated the same, which is a feature in a way of the mass claims processing. After these, the authors have continued with the modeling assumptions, which you can see 2 pages later, and you will see there that they have discussed how many hours they should have used, how to calculate the day, and at the end they have agreed on a 12-hour day and 7 days per week, which is correct in my view. And then the most important figure for me in the whole report comes out in page 78. I'm sorry, in page 28. This is the amount of wage of a worker and for 1 day, 0.78 cents, 78 cents of dollar per day. This seems small, but this is the basis of all the 54 trillion calculation that comes later. So for me, this is very important that this figure be really justified and well established and supported. And page 31, table 3, which shows the total amount that, as was mentioned, amounts to 55 trillion for the loss of life and uncompensated later. In table 4, which is in page 32, the authors have shown the sensitivity to assumptions, which comes from the interest rate in that. And you see that the 54.8 trillion goes at the middle and relates on 2 criteria. One is the rate of interest, 2.5, which includes inflation and real rate of interest, and the other one is the non-US wage proportion to a US wage. In this situation, it has been assumed that the wage are the same, and they are 100%, so they are the same wage. It comes to this, which seems conservative. As I said, it seems that the interest has room to change a bit because of the risk and because of the comparison, but otherwise it seems fine here. Now, and my conclusion on this part, very briefly, the methodology used as a whole resembles mass claims methodology, but at the same time, it misses some important elements that normally we see in the mass claims processing. I'm not saying this is because of the authors. Most of these, I'm sure, could be explained because of the situation and because of the lack of information and the vastness of the task. The steps that in a standard claims processing one normally sees is sampling. When you have a large population, a huge population like here, you will take a sample, you will study the sample, then you try to make sure that you have a representative sample, and that representative sample will be decided by a statistician who will take into account the total populations and then the number of what would be representative. Then you would work on profiling on this sample and prepare some general profiles that could be applied to the rest of the populations. This makes the task very easy, and it seems until here, this is in fact what our authors of the report have done. What is not here probably is that at that stage, then you will have to do some regression analysis and go back a bit and look at the outliers, the ones who stand out. For instance, if you have taken into account in profiling that the salary of the workers were, I don't know, $700, then you see there are some people who are asking for double and there are some people who are asking for lower. Then you will look at those outliers to find out the reason, see what was the reason. That we don't have here, probably because it was not possible, lack of information. That is, in this situation, unfortunately, that's always an explanation. In addition, which I'm hoping it will be this one, it was not needed. I mean that the population and the samples and the rest were so similar that there was no need to separate some of them and profile them and apply them, and there were no outliers. Now, if I like to go to the page 43 to 45, which is non-quantified harms.
It's on the screen.
Yes, thank you. Yes, this is the place that the authors explain that the psychological harm has not been calculated and put, but they also show that the lack of quantification is not an indication of the unimportance of these avenues of harm, and we therefore address them briefly below, which they refer to and all that. What I like to, not to take too much time, what I like to do is to go directly, Wes, please, to the other documents that I gave you. What I like to mention here is that in the United Nations Compensation Commission that many of you know, it was set up in 1991 after the invasion of Kuwait by Iraq at the time, and the war by the Allies against Kuwait and liberation of Kuwait. An unprecedented compensation commission was set up by the United Nations the first time, and the Security Council was the governing body. The UNCC was a subsidiary organ of the Security Council. It had three organs: Governing Council, Secretariat, Commissioners. Governing Council was setting the policy, i.e. the Security Council. It was represented by the same membership, a secretariat that served the Governing Council, and then panels of commissioners. We had 17 panels of commissioners of highly qualified jurists and other professions who decided on the claims. The secretariat prepared the work and they decided on that. Question of mental pain and anguish, sorry, I use this because this is the way it was referred to, psychological harm in UNCC. It was called mental pain and anguish. It was one of the first issues that came up you see that this is decision 8 of the Governing Council, which had about 300 decisions. So, but this was one of the first one. And in fact, they decided in decision 3 on mental pain and anguish, but there were no amounts, and asked the Secretariat for a paper to explain how this could be done. And we did, and I worked myself on that a lot, and we prepared information for the Governing Council, and then they came up with this decision. As you will see here in this, I open my version here. There are a number of mental pain and anguish that has been decided on and agreed on, and practically for any types of loss, apart from torture, hiding, hostage taking, witnessing, I mean, being subject to harm or witnessing harm to a family member, they are all been provided compensation for. And the amounts, and for the sexual assault, for instance, there is a mental pain and anguish, which is natural. And I use this opportunity to say that when yesterday on the first panel, this issue came up, I fully agree that the number of persons, the number of female persons there should be in the report. I think it will be quite justified to be increased to 100%, but maybe for the men a percentage could be added. But you see that the UNCC, these are all there. In addition, the last one is very interesting, that one of the members of the council wanted to add at the end, that if someone is in a situation that is deprived of all economic resources and lots of difficulty, even that is a psychological harm, and there should be compensation for that, for that part. I leave you to read it later. It is available to the organizers. And I also remind you that decision 3 also is important. So read these two together. Now for here, I would suggest to do it the same way as was done at the time in UNCC. Of course, at that time, the current resources were not available. And now it's easier to make research and find more precedents to add this. The first stage should be to think about what should be the heads of losses for psychological harms. And then the second would be what should be the amount to be allocated for each of these harm. I like to stop here with a short conclusion. I think the report is an excellent report. A small point I hadn't mentioned, another issue that it doesn't mention, and yesterday also was not mentioned, what is the margin of error in this report? Normally, I mean, our authors have been very open, so they can mention that as well. And as you know, a percentage of, I don't know, 4, 5, 6% in every report is normal. In this situation, I think it can even go higher and can go up to 10% or around 10%. So they shouldn't worry about that. I also want to mention that when I say that there is a need to prop up the reports more, to have background information, to add more statistics and all that. First of all, I don't mean to create work for the authors. I mean, others can do that. Organizer can find a way to do it, but and also the legal aspects, of course, to do that. And second, also, I am personally convinced that even with more work, the result will not be much different. And that is one of the reasons, one of the important elements for mass claims processing. Mass claims processing is not an exact science. You will not pay each person the exact amount that they are owed. You pay them an approximate amount, but it's possible to pay an exact amount, but then they have to wait 5 years, 10 years for their turn, for the processing and all that, for like the normal courts that it takes time. Here is the same. I mean, if you want a quick report and go that, then that's it. And the marginal error will be higher. Again, it's an excellent report, but there is room for some improvement and for some additions, and in particular, and mainly the question of psychological harm, or MPA, as it was called in the jargon of the UNCC. Thank you very much.
Dr. Kasazi, thank you very much for your contribution. I am sure that in addition to those of us who have been following and watching, and those who are watching the YouTube stream, that our colleagues from the Brattle team were indeed watching very keenly and following your observations. And we may very well hear from them separately outside of the context of the symposium, of course. In terms of what can be made available to the public, thank you very much for pointing us towards the decisions of the UN Compensation Commission, including in mental pain, anguish, and suffering, and how that maps on to psychological harm. We can absolutely post those to the website as well. They are publicly available as they are UN documents. So they will be as available for consultation as the Brattle report itself is. We will now turn to Professor Shepherd, whose contribution to both symposia, and in particular in her role as a historian, as an advocate in these issues for many years, has been incalculable to the subject of this symposium. Professor Shepherd, you have the floor.
Thank you very much. I will try to be brief. I just wanted to make a few comments on some of the issues raised yesterday and today. First of all, I really want to appreciate all the work that has gone into this by the Brattle Group, and all the work that Judge Robinson and colleagues yesterday and today put into this effort. This is really marvelous. And Judge Robinson, thank you again for having asked me to play some role into the contents, the contents already there and those that will be added. Now, yesterday we were talking about genocide because of the drastic population decline in the Caribbean. I wanted to just say that it is true. And I was listening keenly to Judge Yusuf. There was an anti-natalist policy in the Caribbean up to the abolition of the transatlantic trafficking in enslaved Africans. Well, the act anyway, because we know it continued illegally, still illegally, way beyond 1807 in the case of the British Caribbean. Now, the almost motto of these planters in the Caribbean was, it is cheaper to buy than to breed. And demographic historians have written about this for a long time. So the treatment was deliberate, the chattelization, the dehumanization, the construction of the codification of laws to declare our ancestors non-persons, all of that was deliberate. And death was not only because of disease, it was because of mistreatment, and it was because of deliberate killing. The Maroons, for example, waged an 80 years war against the British, and the casualty rate was high, I guess on both sides. But there was deliberate killing of protesters over the 2 centuries of the British being in the Caribbean. You have to look at what happened after every war of resistance to see the deliberate hanging, the murder of people. So I don't accept that we can't use genocide because it wasn't really deliberate what happened. It was almost like a casualty of the system. That's one. Then when we come to the post-slavery, the post-trafficking period, when there was suddenly a pro-natalist policy, we have to understand also that there was resistance to that by the enslaved. The planters in the post-1807 period in the British colonized Caribbean attempted to base the regeneration of the enslaved laboring population on women. So women's conditions would have been placed at the center of this sudden pro-natalist policy. This would require the cooperation of women. And the literature, the historiography is replete with scholars on gender issues showing that women were not cooperating. They could have fed them some more. They could have taken them out of the field some more. They had control over their bodies. And so there was a deliberate attempt by enslaved women not to cooperate. In other words, what I'm saying is that we have to factor in these issues when we're talking just with figures. Figures alone can't tell the whole story. And that's why we have the work of people like Professor Barry Higman from the 1980s. He's a quantitative and demographic historian. And then when we come to talk about USA, sometimes I get the impression that we talk in glowing terms about pro-natalist policy there and treatment. We have to remember that, and historians have written about this for a long time, when we talk about demographics, we have to consider the place that we're talking about. In other words, it is well known that the death rate was highest where enslaved people worked in the sugar plantation. However, there were contexts, both in the US and in the Caribbean, where enslaved people did not work on sugar plantations. And it is shown that the demographics in those contexts would have been different from on the sugar plantation. Now, it may not have affected that much the overall population increase or decrease, but we have to be careful when we're generalizing across economic enterprises in the Caribbean. And then we have to also remember that part of what happened in the United States of America, and Fogler and Engerman have written about this for a long time ago, it was deliberate breeding. Some of it was deliberate breeding because as the colonization continued, as the United States tried to open up to the West, my understanding from reading US historians, some of them, is that there was an attempt to use the regeneration of the enslaved population to help to conquer new lands. And so, again, it wasn't because they liked enslaved people and wanted to treat them better. I think we have to nuance that kind of argument. And so those were the few comments. And maybe finally, again, I was reading the QC Gifford, Anthony Gifford. And in defending reparation and looking at the legal aspects, he has said that there's no statute of limitation in talking about reparation for a crime against humanity. And I think we have already concluded that the whole trafficking and chattelization were illegal at the time they were committed, and that reparation is justified. And also in terms of the descendants and those living with the legacies, he also says that there is nothing in international law which prevents descendants who have never, of ancestors who never got compensation for claiming on behalf of their ancestors. So I hope that this could be maybe debated a little bit more And then maybe I should also say that I agree with Judge Yusuf. And it is I'm a historian, it's a painful thing for me. Judge Robinson and I talk about this all the time. The way in which the education system is done, preparing our children, each generation, to know what happened and to ensure that they pass on this knowledge. Caribbean history is not compulsory beyond a certain level, the lower levels in the schools. And even when it is done at the higher levels, it's a choice. We have been pushing to change this, and Judge Yusuf is right. If the Dutch apology and what transpires this year does not filter down into the curriculum, if there's not curriculum reformation, then this will just stay, and the old people will know and the young people won't know, and so on. So this is an effort of quantification. It's just that surrounding it has to be a context, and this might not be a numbers context. And then I listened carefully also to Judge Yusuf about to whom will this be paid, whatever the quantity, and how will it be used? And again, since 2013, the CARICOM heads of government tasked the CARICOM Reparation Commission with drawing up or answering just that question. And for the region, there's a 10-point plan which talks about why and who should be entitled, and how, and the avenues through which that repair should take place. So it's not a payout. It is apology. It is debt cancellation. It is technology transfer. It is attention to psychological harm, to education, to health, so that it's an infrastructure, social infrastructural blueprint or strategy towards repair. So I just wanted to throw out those comments and again to thank everyone for this wonderful work. Thank you.
Thank you very much, Professor Shepherd. Indeed, again, not just for those comments, but for your contribution to the work of the symposium and for your enduring work over the decades on these critical issues. We now turn for the closing remarks for this symposium to Judge Patrick Robinson, the chair of the symposium. Judge Robinson, you have the floor.
Thank you very much. Ladies and gentlemen, I take the opportunity to thank all of the participants in the symposium, Sir Hilary Beckles, as well as all of those who discussed the Brattle report, Judge Yusuf, Dr. Mamadou Hebi, Professor Adrian Wing, Dr. Mushtabu Kazazi, and Dr. Don Marshall. Of course, on behalf of the symposium, I express my gratitude to the Brattle Group of Evaluators for the very significant work they have done in producing this report. And if you'll allow me, ladies and gentlemen, I'd like to mention that the work was done pro bono. I must also thank Professor David Eltis for his groundbreaking research on slave voyages, which has played a pivotal role in the symposium work on the quantification of reparations. And thanks are also due to Samantha Campbell and Michael Hilton, two young Jamaicans who prepared valuable tables which assisted the Brattle Group in its work. I'd like also to thank Ms. Priscilla Robinson, who has assisted me in my work as a member of the symposium's advisory committee. Now I have to, in the Jamaican language, big up Ms. Natalie Reid, who made the administrative and other arrangements for the symposium. How she was able to do that in combination with her law practice, I will never be able to understand. We are also indebted to Professor Chantal Thomas, who introduced the discussions yesterday. And finally, my thanks to Professor Gregory Schaffer, who is the president of the American Society of International Law, for his introductory remarks. Ladies and gentlemen, the Brattle Group have quantified the reparations due for TCS at over $101 trillion. This figure comprises approximately $78 trillion as reparations for the harm caused during enslavement, and approximately $22 trillion for the harm caused in the period after enslavement. These figures are what former slaveholding countries are required to pay by way of compensation to the descendants of the enslaved. In respect of the period during enslavement, Table 29 sets out the sum that each country in which enslavement was carried out is entitled to receive as compensation. It also identifies the former slaveholding country to pay that compensation. And Table 18 sets out the compensation in the post-enslavement period that each country in which TCS was carried out is entitled to receive. At the same time, it identifies the former slaveholding country that is to pay that reparation. And I just mentioned, I am not insensitive to what Judge Yusuf said about who is to receive the compensation, what groups of people will have to attend to that. Ladies and gentlemen, the symposium is historic in that it has, through the Brattle report, comprehensively set out the sums to be paid by all former slaveholding countries to all the descendants of the enslaved. In that regard, please recall that in my opening remarks, I said that we, descendants of the enslaved, wherever we are today, we all came to these parts on the same boat. Of course, the symposium, as acknowledged in the report, has built on the work done by many others in the field, including Professor Hilary Beckles, Professor Vereen Shepherd, and Professor Robert Beckford. I wish to comment on one aspect of the report. It shows that reparations in the sum of about $78 trillion must be paid by a number of former slaveholding states to the descendants of the enslaved in several countries for wrongful conduct during the period of enslavement. Of that sum, to take an example, Jamaica is to receive $7.5 trillion, and the United Kingdom is required to pay as compensation to the countries in which it carried out TCS some $19 trillion. Now, by any measure, these are large sums. I'd like to make the following comments. Brattle's report is of a very high quality, evidencing much learning and scholarship from experienced economists and valuators. The methodology is carefully explained, and it shows an admirable rigor in its analysis. Moreover, Brattle has been conservative in its conclusions. In its work, Brattle had to make assumptions about the number of people born into slavery outside the United States. For every enslaved person embarked to the United States, 22 persons were born into slavery. However, this ratio was likely lower in other countries. For example, the calculation used in the documentary The Empire Pays Back assumes one person born to slavery for every 3 that were embarked. As a conservative assumption, the Brattle Group followed this 1-to-3 ratio in their calculations. Moreover, although there was more than ample evidence to support an interest rate of 3%, Brattle used the lower rate of 2.5%. Why then are the figures so high? Ladies and gentlemen, the figures are high because the period for the calculation of compensation at a particular rate of interest runs for hundreds of years from the date of enslavement to the present day. The report makes the point that the payment of interest preserves the time value of money, and that one of the purposes of an interest rate is to offset inflation. It is interesting to note that the International Law Commission's articles on state responsibility explicitly address the question whether the principle of full reparation may lead to disproportionate and even crippling requirements so far as the responsible state is concerned. The commentary on Article 34 refers to the principle of proportionality as an aspect of the obligation to make full reparations. Thus, Article 35 precludes restitution if it would involve a burden out of all proportion to the benefit gained by the other injured party. Similarly, Article 36 states that satisfaction should not be out of proportion to the injury. While there's no such provision in relation to compensation, it has to be noted that under Article 36, the obligation is to compensate for damage that has actually occurred as a result of the wrongful conduct. The question whether compensation may be too burdensome for the responsible state was recently addressed by the International Court of Justice. In its 2022 judgment, in the armed activities on the territory of the Congo, Democratic Republic of the Congo versus Uganda, a war that lasted 5 years between the two countries, the ICJ considered the question whether, in determining the amount of compensation, account should be taken of the financial burden imposed on the responsible state, given its economic condition, in particular, if there is any doubt about the state's capacity to pay without compromising its ability to meet its people's basic needs. And after considering the total amount of compensation awarded to the Democratic Republic of Congo, as well as the terms of the payment of the compensation, the court concluded that it was, here I quote, satisfied that the total sum awarded and the terms of payment remain within the capacity of Uganda to pay, end of quote. Ladies and gentlemen, I would not conclude without addressing the important issue raised by Dr. Mamadou Heby yesterday. Dr. Heby observed that in determining the number of persons born into enslavement, the Brattle Group had 2 options. It chose the lower option, following the approach taken in the documentary, The Empire Pays Back. That documentary, as already mentioned, worked on the assumption that for every 3 embarkations to the Caribbean, 1 person was born into slavery, as distinct from the situation in the USA, where 22 persons were born into slavery for every one enslaved person embarked to the United States. It appeared to Dr. Havey that this approach was taken by Brattle because it was safer and more conservative. But Dr. Havey, good international lawyer that he is, questions whether a determination should not have been made as a matter of law as to the number of persons born into enslavement. He has raised an important issue relating to the allocation of decision-making responsibilities concerning the work of the symposium. When I started examining the legal framework for reparations for transatlantic chattel slavery, I immediately realized that reparations could not be determined by experts without some other body having a role in that determination. There had to be a body that would receive the reports of the experts and ultimately come to a conclusion on the reparations that are due. And that was why I established an advisory committee. But admittedly, I was very conflicted as to the role of this committee. At times I felt that it was for the committee and not for the experts to determine reparations on the basis of the principle of equitable considerations. In the result, the matter was never settled, but we do have an advisory committee, and one of its functions is to resolve difficult issues. In relation to the particular matter raised by Dr. Havey, I should say that the determination of the number of persons born into enslavement should be made as a matter of law on the basis of the principle of equitable considerations, which I explained yesterday. Essentially, it allows for a reasonable estimation. In conclusion, then, Brattle's lower assumption is consistent with the principle of equitable considerations. But Dr. Havey raised another matter. He raised the issue of reparations for Africa resulting from transatlantic chattel slavery. I had included population displacement as a head of damage in one of the earlier iterations of heads of damages. I believe it was felt that we should concentrate on reparations for the descendants of those who were enslaved in the Americas and the Caribbean. However, there can be no doubt that the population displacement experienced by African countries significantly affected their growth and development. And after hearing from Dr. Havey and Judge Yusuf on this matter, I want to say that this is a matter that deserves the attention of the advisory committee, and we will look into it. May I just briefly comment on what Judge Yusuf had to say about Article 30 and the obligation to cease a wrongful act if it is continuing. He is absolutely right. And I thank him for reminding us. We tend to take things for granted sometimes, you know? But it is very important that in our work, we should tell the former slaveholding countries that they must cease the wrongful act, the discrimination that continues, you know. And he's also absolutely right about focusing on the descendants of the enslaved. Doesn't mean that you forget our ancestors. But what we face today is a set of people who are disadvantaged and generally impoverished on account of transatlantic chattel slavery. Also, he was absolutely correct about the stress on the Netherlands and other countries providing an account of the violations in educational materials at all levels as a form of satisfaction. And Professor Shepherd has addressed that. And I'd also like to thank Dr. Mujtaba Kazazi for what he has just told us. In particular, Dr. Kazazi being a practitioner in the field, he has brought his experience to bear, and he has drawn our attention to the practice of the UNCC, which we will look at in relation to psychological harm. I remember that yesterday, Professor Adrian Wing pointed to a law in, not sure whether it is in her state or in the US state at the federal level, that has a provision in relation to compensation for psychological harm. So those are two areas that we need to look into. Ladies and gentlemen, in closing, let me say that the advisory committee will examine the report, taking into account the indubitable claim of the descendants of the enslaved to full compensation, as well as the possibility that the sums identified in the report as compensation may be burdensome. And we will also take into account the law relating to it. The committee will consider this matter and provide a report on the sums to be paid in short order. Thank you very much. Those are my closing remarks. Thank you.
Thank you very much, Judge Robinson. In just wrapping up the proceedings of the second symposium, taking account, of course, of the very important contributions and the dialogue, and to a certain extent, the debate that has been taking place among the participants in this symposium. It would be remiss if, and on behalf of those who have played a role in organizing both symposia, I did not, of course, acknowledge and again thank the University of the West Indies and the Center for Reparation Research for their incredibly important support for the symposia, and of course the substantive contributions of Vice Chancellor Sir Hilary Beckles and Professor Shepherd in their capacity as historians in this field as well. And of course, the virtual platform and the facilitation of this conversation over the course of the last few years, and the maintenance of the web page that makes all of this possible is due to the commitment and the support of the American Society of International Law, which of course began under the previous president and previous executive director, Catherine Amerifar and Mark Agrast, and continues with the current president, Greg Schaefer, the current executive director, Michael Cooper. And we are, of course, we remain indebted to the staff of ASIL at Tiller House, with whom much is possible and to whom we remain indebted, in particular Wes Rist and Jimmy Steiner and their colleagues as well. The recordings of all the days of the symposia, 4 in total, will remain available on the site, as will the materials for the first symposium and those that have and will be posted for the second symposium. Again, I think we have heard this from all of the speakers in recognition of the truly significant contribution that these symposia have made and the unprecedented work done by many of our participants. The role of ASIL in making that webpage available and continuing to be available will serve an important educational role as well. But as Judge Robinson, Professor Shepherd, and so many else have said, that is only part of what the project entails. So with that, we will leave you all. For those who are watching, good day, good evening, and good night, wherever you may be in the world. And for those who watch these recordings later on, thank you for your attention to these matters.